Confidentiality is recognized within the law. Article 8 Right to respect for private and family life of the European Convention of Human Rights states, everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority with the exercise of this right except such as in accordance with the law, and is necessary in a democratic society in the interests of national security, public safety or the economic well-being of the country, for the protection of health or morals, or for the protection of the rights and freedoms of others. The common law of confidentiality reflects that people have a right to expect that information given in a healthcare setting, whether a clinic or outreach, is only used for the purpose for which it was given, and will not be disclosed without permission. This covers situations where information is disclosed directly to the Terence Higgins Trust healthcare worker and also to information that they obtain from others. One aspect of privacy is that individuals have the right to control access to their own personal information. It is not acceptable for any Terence Higgins Trust staff member to discuss matters related to the people in their care outside the clinical setting. Discuss a case with colleagues in public, where they may be overheard. Leave records unattended where they may be read by unauthorized persons. Confidentiality has special significance within the sexual health setting due to the private nature of sexual behavior, the stigma that can accompany sexually transmitted infections (STIs) and the damage to relationships if infidelities are exposed. Without a promise of confidentiality, people may be less likely to come forward for sexually transmitted infections testing, treatment for infections, follow-up appointments and participate in partner notification procedures. The protection of the individual's privacy within the clinical or outreach setting is of utmost importance to the doctor, nurse or outreach worker attending the client. Discussions or examinations should not be overheard or observed by anyone who is not directly involved in the delivery of care, unless the client has given their prior consent. The protection of the client's records, whether paper or electronic, is a priority. These should only be available to staff directly involved in the delivery of care. Any other information for reporting or audit purposes and therefore for wider circulation must be anonymized. All client paper records must be stored in locked cabinets. All electronic records must be supported by the individual staff member's password. Computers must not be left unattended, making it possible for clients' records to be viewed. Only those who need to have access to the records will be allowed to access them. All clinical records must be stored separately from the rest of Terence Higgins Trust's client files, and must be provided with a unique identifying number. Files must be stored in locked cabinets when the clinic is closed. Protection of the identity of clients. Appointment lists should not be visible to other clients. Under no circumstances will enquirers be told whether an individual has an appointment or is attending a clinic. Protection of data capable of identifying an individual patient. These will not be used for teaching, research, epidemiological surveillance or publication purposes, without prior consent from the client. Protection of client information. Details of a named client's sexual history, diagnosis or care should not be shared with a third party outside the care team, unless written consent is given, exceptional circumstances exist or if required by law. Clients understand the limits of confidentiality. Patients should be informed effectively of the limits to confidentiality, so there are no surprises. Limits are outlined within this document. An acceptable means of contacting each client, should the need arise, must be agreed with the client before testing. Where possible, clients should be encouraged to provide two means of contacting them: an address and a telephone number. Discretion when encountering a third party in the process of partner notification or client recall should be observed. All clinical staff and volunteers working in Terence Higgins Trust services should be aware of the issues surrounding confidentiality and seek support and guidance when uncertain on how to deal with these issues. All possible or actual risks of breaches of confidentiality should be reported to the service manager and a clinical incident form completed. Clients. Confidentiality must be respected in response to inquiries from external individuals or organizations, e.g., media, insurance companies, and police. In these circumstances, express consent must be obtained from the client, and/or proper legal authority demonstrated before any disclosure can be made. The clinical director must be informed if any requests of this nature have been made. Disclosure means the giving of information. Disclosure is only lawful and ethical if the individual has given consent to the information being passed on. Such consent must be freely and fully given. Consent to disclosure of confidential information may be explicit, implied, required by law, capable of justification by reason of the public interest. Clients have a right to expect that the information they provide will be held in confidence. Confidentiality is central to the trust between trust staff and their clients. However, clients should be made aware that certain exceptional circumstances may require disclosure of confidential information. Clients. Confidentiality must always be respected. Seeking consent to disclosure of information is part of good communication between staff and clients. There are circumstances where clients may give consent to disclosure. Explicit consent is obtained when the client agrees to disclosure, having been informed of the reason for that disclosure and with whom the information may or will be shared. Explicit consent can be written or spoken. Implied consent is obtained when it is assumed that the client understands that their information may be shared within the healthcare team or with outside healthcare providers. All Terrence Higgins Trust staff providing healthcare should make the client aware of this routine sharing of information, and clearly document any objections in the client's records. The General Medical Council identifies a number of exceptional circumstances where disclosure may be permitted without consent. You should inform clients about such disclosures, wherever that is practicable, but their consent is not required. Disclosure is required by law. Disclosures to courts or in connection with litigation. Disclosures to statutory regulatory bodies. Disclosures in the public interest. Disclosures to protect the patient or others. The term public interest describes the exceptional circumstances that justify overruling the right of an individual to confidentiality in order to serve a broader social concern. Under common law, staff are permitted to disclose personal information in order to prevent and support detection, investigation and punishment of serious crime and/or to prevent abuse or serious harm to others. Each case must be judged on its merits. Examples could include disclosing information in relation to crimes against the person, e.g., rape, child abuse, murder, kidnapping, or injuries resulting from knife or gunshot wounds. These decisions are complex and must take account of the public interest in ensuring confidentiality against the public interest in disclosure. Disclosures need to be proportionate and limited to the relevant detail. All requests of this type must be referred on to the clinical director, or in their absence another appropriate senior member of staff for guidance. No disclosures may be made unless the clinical director, or in their absence another senior member of staff, is aware of them. When information is disclosed without the client's consent, this must be recorded in their health record and the member of staff must be prepared to justify their decision for disclosing patient information without consent. The police have no automatic right to demand access to a person's medical records. To do so, they must obtain a warrant under the Police and Criminal Evidence Act 1984. The police have no duty to inform the person whose confidential information is sought but must inform the person holding that information.